The practical implication of maritime arrest procedures in domestic law in Germany and Sweden. The following thesis gives an insight into the recent development in international law on the arrest of ships, as well as the practical implication of maritime arrest procedures in domestic law in Germany and Sweden. In practice, only a short time is available for inquiries concerning the prospect of success of a creditor's application for arrest or the debtor's possible defenses. The legal procedures arising from an arrest may last for years and raise important questions for high economic value for both parties. Often the maritime arrest is the last hope for the creditors to retrieve money from a debtor, and for the debtor such a procedure means a major irritation for his business, often with heavy financial consequences regarding demurrage or loss of a time charter. In a foreign port, the vessel usually represents the debtor's only asset reachable to the creditors. Ships, as being movable, are easily withdrawn from judicial execution. Perils of the sea and right could also depreciate the value of a vessel. In many legal systems, finally, the liability in personam is distinguished from the liability in rem, that the creditor might, with a claim, might have to enforce it against a particular vessel. Consequently, he is dependent on immobilizing the vessel by a quick arrest. Such an act causes a lot of inconvenience and is regularly not good for mutual business, but it might be the ultimate mean of retrieving security for claim and is therefore sometimes unavoidable. Nevertheless, arrest should be considered as the last resort. Therefore, it is all the more important that the arrest procedures are clearly defined and well understood by those who have recourse to it. The problems of maritime arrest are of great practical and academic significance, not only in the light of the new 1999 Arrest Convention, but also of development in domestic law. The Arrest Convention. The 1952 Arrest Convention, after more than 20 years of preparation, a diplomatic conference in Brussels in May 1952 resulted in the International Convention for the unification of certain rules relating to the arrest of seagoing ships, for the approximation of domestic laws to the advantage of international shipping. Only four of the nine European Economic Community or EEC countries at that time ratified this convention, namely Belgium, France, Germany, and the United Kingdom. The purpose of the convention was to restrict the possibilities to arrest ships in foreign port among the contracting states through such a approximation. The convention, however, is to be seen as a compromise between common law on the one hand and civil law on the other hand. The 1952 Arrest Convention falls into two parts. Articles 2 to 6 regulate the condition for arresting a ship and for its release, while Article 7 is concerned with jurisdiction based on arrests made in accordance with the previous articles. The compromise character of the convention is conspicuous, especially with regard to requirement of an arrest claim to be maritime. Civil law considers a vessel as an asset which may be arrested no matter whether the claim to be secured is of maritime or non-maritime nature. On the other hand, common law allows an arrest in ship only for maritime claim, but just as long as they arose from the operation of the particular vessel. These two legal approaches have been taken into account in Article 2 and 3 of the 1952 Arrest Convention. An arrest is allowed according to Article 2 only in respect of maritime claims specified in the catalogue of Article 1 of the 1952 Arrest Convention. These are the majority of claims which could arise with regard to the operation of a ship. 1. Damage caused by any ship either in collision or otherwise. 2. Loss of life or personal injury caused by any ship or occurring in connection with the operating of any ship. 3. Salvage. 4. Agreement relating to the use or hire of any ship, whether by charter party or otherwise. 5. Agreement relating to the carriage of goods in any ship, whether by charter party or otherwise. 6. Loss or damage to goods including baggage carried in any ship. 7. General average. 8. Bottomry. 9. Towage. 10. Pilotage. 11. Goods or materials wherever supplied to a ship for her operation or maintenance. 12. Construction, repair, or equipment of any ship or dock charges and dues. 13. Wakes of master, officers, or crew. 14. Master's disbursement, including disbursement made by shippers, charterers, or agents on behalf of a ship or her owner. 14. Dispute as to the title to or ownership of any ship. 15. Dispute between co-owners of any ship as to the ownership, possession, employment, or earning of that ship. 16. The mortgage or hypothecation of any ship. The claim under letter 1 and 2 are a special nature since they do not always pertain to money. Claims of insurers for overdue premium as well as Social Security institution for contribution aren't mentioned. An important exception, however, from the applicability of the Convention has been made concerning the protection of claim under public law. According to this exception, the provision of the 1952 Arrest Convention shall be of no effect with regard to right and powers of public and port authorities of a state to arrest or otherwise to prevent the departure of a ship according to its domestic law. Hence, despite the 1952 Arrest Convention, the authorities have the right to take action against a vessel to secure claims under public law. A private claim of an authority, however, isn't covered by this exception. According to Article 3.1 of the 1952 Arrest Convention, the claimant may arrest either the particular vessel in respect of which the maritime claim arose or any other vessel which is owned by the person who was, at the time when the maritime claim arose, the owner of the particular vessel in respect of which the claim arose, even though the vessel arrested be ready to sail. If permitted by the law of procedure as an exception from the prohibition of arrest according to Article 2 of the 1952 Arrest Convention, the creditor has also the possibility to obtain security even in another ship of the same operator or sister ship, as long as either the owner is liable or the sister ship is liable for the maritime claim. According to subsection 2, this is also applicable if any other owns all shares in the vessel. This provision is a quiet, concise, and therefore hard to interpret. It might be better understood with respect to the following examples by Berlingeri. Within this example, A shall be the vessel in respect of which the claim arose, and B shall be another vessel. If a vessel A is fully owned by X and vessel B by X and Y, vessel B cannot be arrested because of a maritime claim. If vessel A is owned by X and Y, however, and vessel B is fully owned by X, vessel B can be arrested because of a maritime claim. If a vessel A is owned half by X and each a quarter by Y and Z, and vessel B is owned to equal shares by X, Y, and Z, vessel B can be arrested because of a maritime claim. If the vessel A and B owned by two joint stock companies and all stock are held by X, vessel B cannot be arrested because of a maritime claim because the companies are considered as being two independent legal persons. Hence, the creditor may arrest because of a maritime claim only one ship, either the ship in respect of which the claim arose or a sister ship. Thank you.